Okay, listen now. Jurisdiction shopping is not the same as attempting to simulate a proxy process regarding some form of remote locationing or attempting to try to subject you real time to elements that are attempting to occur in a co-location. All right? Just so you know. They're not going to explain it like this. They're going to tell you any other fucking thing. I'm sorry. They're going to tell you any other thing. What's happening literally in the moment, they have to obey the law. They can't say, oh, don't worry. I know what I'm doing. Oh, don't worry about the rule. Oh, we don't do that anymore. They have to be held accountable. So the first thing they have to be held accountable for is this right here. It's going to take me a second. I just have to look it up. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Amendment 5. No person shall be held to answer for capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of a law, nor shall private property be taken for public use without just compensation. Now, the thing you really need to pay attention to is this part. Except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. What's public danger? They say it's an emergency because it's a health pandemic, but there's no declaration of war. If they do not identify themselves as a member of the United States military and tell you about who and identify themselves, that means they are not operating within a chain of command, and they need to be understood that they may be attempting to recruit you into engaging in acts of terrorism. You understand? If they do not identify themselves as a member of the military, then anything they do that tries to relate to the military or invoke the military or simulate the military needs to be regarded as if they are trying to recruit you into agreeing to commit to acts of terrorism. Don't take this lightly. And anything else they try to do needs to be understood from that position. The burden is on them. It's not on you. Article 3, lawyer-client privilege, Section 950, lawyer. As used in this article, lawyer means a person authorized or reasonably believed by the client to be authorized to practice law in any state or nation. If you are representing yourself, if you need to represent yourself, and they refuse to provide you with an attorney, and yet attorney, if they do provide you with an attorney, the attorney refuses to represent your interests, you have a right to represent yourself pro se. And if they're trying to get you to agree to commit to crimes, these are criminal charges. This is a crime. It's not just a violation of your civil rights. These are crimes. They're trying to extort you into agreeing to cooperate with crime. You have a right to defend yourself. Section 951, client. As used in this article, client means a person who, directly or through an authorized representative, consults a lawyer for the purpose of retaining the lawyer or securing legal service or advice from him in his professional capacity. It includes an incompetent, A, who himself so consults the lawyer, or B, whose guardian or conservator so consults the lawyer in behalf of the incompetent. In the state of Texas, there are very specific laws. You are presumed to be competent until they prove, beyond a shadow of a doubt, under the letter of the law, which they have to put on the record and substantiate on the record, that you have been adjudged to be mentally incompetent. If they haven't proved it, they have no reason to deny you as consideration as if you are a client, and you should be accorded the protections of counsel. Section 952, confidential communication between client and lawyer. As used in this article, confidential communication between client and lawyer means information transmitted between a client and his or her lawyer in the course of that relationship and in confidence by means which, so far as the client is aware, discloses the information to no third persons other than those who are present to further the interests of the client in the consultation of those to whom disclosure is reasonably necessary for the transmission of the information or the accomplishment of the purpose for which the lawyer is consulted, and includes a legal opinion formed and the advice given by the lawyer in the course of that relationship. They don't have a right to spy on you, to steal your emails and your notes, including to yourself, and then try to tell you that they had any justification for doing it. If they give you a lawyer, your lawyer needs to help protect your rights, including rights to privacy and private communications. If you are forced to represent yourself pro se, then you need to understand everything you do to record your reflections, including your states of mind, including whatever you understand is going on, including in concurrent processes, including your emotions, including any efforts that anybody else is trying to make to extort or entice or seduce you, is potential evidence, and you have a right to acquire evidence and to have it secured against anybody trying to steal it and use it against you. Section 953, holder of the privilege, is used in this article. Holder of the privilege means if the client has no guardian or conservator, be a guardian or conservator of the client when the client has a guardian or conservator. The personal representative of the client if the client is dead, including a personal representative appointed pursuant to Section 12252 of the Probate Code. A successor, assigned, trustee in dissolution, or any similar representative of a firm, association, organization, partnership, business trust, corporation, or public entity that is no longer in existence. If they try to pull some sort of age preclusion saying that you are obligated to be put under some sort of conservatorship or guardianship, that does not mean they're your lawyer. And if they try to engage you or compel you or try to persuade you to engage in anything at all that is criminal, or that anything that attempts to compel you to agree to do anything criminal, they are not fit to be in any representative role. Section 954, lawyer-client privilege. Subject to Section 912 and except as otherwise provided in this article, the client, whether or not a party, has a privilege to refuse to disclose and to prevent another from disclosing a confidential communication between client and lawyer. The privilege is claimed by A, the holder of the privilege, you, B, a person who is authorized to claim the privilege by the holder of the privilege, or C, the person who was the lawyer at the time of the confidential communication, but such person may not claim the privilege if there is no holder of the privilege in existence, or if he is otherwise instructed by a person authorized to permit disclosure. You have to permit them to disclose. And at the same time, they are obligated to provide you with information about what they are doing when it comes to whatever their assessment or analysis is as a justification for what they are doing to you or trying to get you to do. The relationship of attorney and client shall exist between a law corporation as defined in Article 10, commencing with Section 6160, Chapter 4, Division 3, and the Business and Professions Code of the persons to whom it renders professional service, as well as between such persons and members of the state bar employed by such corporation to render services to such persons. The word persons is used in this subdivision includes partnerships, corporations, limited liability companies, associations, and other groups and entities. Now, federal rules are somewhat different. So this is the first one you need to know. Rule 509 does not apply. This is not about Rule 509. And if they try to talk to you and invoke Rule 509, you come to tell them to talk to me immediately. And if they don't talk to me within 24 hours, then that means they're a traitor. You are under absolutely no obligation to do anything they say that you need to do or to tell you that you need to do. And if they try to push the point, then it is something you need to put into your evidence, and when the time is appropriate, you provide it as evidence. And if there's anybody else that was witness, make sure that you get the information on that other person as a witness, and the other person's involved as a witness. They are not allowed to try to invoke that with you in or any circumstances. And if they try, you tell them to come talk to the Attorney General of Texas, Charity Colleen Krause. And if they don't talk to me within 24 hours, then I will take the next steps as necessary.